मिस्टर शाह, आपके जो अपोनेंट हैं मिस्टर एस के शर्मा, उनको जरा बुला के लाएंगे तो दोनों जने आएंगे। आपको जजमेंट है ना?
हाँ, तो अभी आए नहीं।
आ जाएंगे, थोड़ी देर में आ जाएंगे। 12
उनके जूनियर
एक बार आ जाएंगे। कौन है जूनियर?
बात हुआ था, अभी पहुँचे नहीं हमसे।
कितनी देर में आ रहे?
हाँ, आ रहे हैं कोटा।
उनको एक बार बुला के कुछ एक इम्पोर्टेंट चीज़ है रिकॉर्ड में जो दोनों ने नहीं बताया है, मैं कंफर्म करूँगा। जजमेंट होगा सेकंड हाफ में 4 बजे के आसपास, लेकिन आप लोग आ जाइए क्योंकि वो कंफर्मेशन के बिना जजमेंट कर देंगे।
एक बार आ जाएंगे उसका सेकंड।
नहीं, आप एक बार आ जाइए 11 बजे चाहे 11:30 बजे।
ठीक ठीक और 11 बजे।
From supplementary list space case for hearing item 7, second appeal 4 of 2016.
They have not actually seen the agreement. Yes, just reached there. Yes. This is agreement between?
My leadership, it is between 6 defendants out of 7.
Who has been left out?
My leadership defendant number 4, he is one of the sons of the person who owned this property.
Sorry, defendant number 4 has been left out. He is son of
Dashrath Prasad, my leadership.
defendant number.
He is not a defendant, late Dashrath Prasad. All the defendants have inherited it from him.
Just a moment. Now, they are all sons of Dashrath Prasad.
Okay. Wife and
So
sons.
sons of the persons who had inherited the property from Dashrath was left out.
Him, one of the sons and 2 daughters also.
They are party in the.
No, no, should be not in party. Yes. This agreement is with this Hasmukh Thakur, my leadership, who is the plaintiff. My leadership at page number 3. It just said that this Dashrath Prasad, the husband of the vendor number 1 and father of vendors 2 to 7, purchased the landed property more fully described in the schedule below from one Rajesh Kumar by virtue of a registered sale deed, registered at so and so. And after the death of this Dashrath Prasad, the vendors inherited the same and have been possessing the same in peaceful and undisturbed possession thereof. Malaysia, the next. The vendors, being in urgent need of money, express their desire to transfer the property more fully described in the schedule below. And the purchaser has agreed to purchase the same for a valuable consideration of 78,000 rupees only, which the vendors have accepted. Now this deed of absolute sale witnesses that the vendors shall sell and the purchasers shall purchase the property more fully described in the schedule below for a valuable consideration of 78,000, out of which the purchaser has paid a sum of 53,500 as an earnest advance money to the vendors, and receipt thereof the vendors doth hereby admit and acknowledge that the vendors will execute and register a proper sale deed in favor of the purchaser within 2 months from the date of this agreement, at the cost and expense of the purchaser on receipt of balance consideration of the money amounted to 24,500. Only before the registering authority at the
One
time
of
of
the sons of
registration.
Dasharatha Prasad is completely excluded from this.
The trial court on this ground and another ground, my lordship, the trial court had dismissed the suit. The first ground was that all the heirs were not party to this agreement, so this agreement could not be enforced. And the second ground was that no readiness and willingness has been shown by way of any evidence by this plaintiff. Because this
Irrespective of readiness and willingness, can this particular agreement be enforced? What happened in that first agreement?
my ladyship, in the appeal, the Limit Court has held that as respondent number 5 was Shyam Kumar Verma, as he was looking after everything, the property and all the things, so it was okay for him to decide
How
because
is it possible? The agreement is not showing so.
Yes, my ladyship. And there is no power of attorney or anything of that sort, my ladyship.
Let us see the findings.
Yes, my ladyship.
First, the trial. Here's the trial.
It's at page number 10 of the appeal, my ladyship.
Let's see the issue straight.
On the basis of the pleadings of the parties, the following issues have been framed. Issue number 1, whether the suit as framed is maintainable and the plaintiff has got valid cause of action. 2, whether there was agreement of sale between the parties on 5/7/2003 for consideration worth 78,000 and use advance payment of 53,100 has been paid to the defendants as alleged. 3, whether parties to contract have always been ready and willing to perform the contract. And 4, whether the plaintiff is entitled for decree or specific performance of contract against the defendants. 5, whether the plaintiff is entitled for any relief. In order to substantiate his case, the plaintiff has examined 5 witnesses: PW1 Haresh Bhatt, Sudarshan Prasad Singh, Jay Shankar Prasad, Prakash Sharma, and Hasmukh Thakur. Apart from the oral witnesses of the agreement dated 5/7/2003 has been marked as Exhibit 1 on record. On the other hand, the defendant has produced only 2 witnesses, namely Shyam Kumar Verma. Only one witness, namely Shyam Kumar Verma. The documents, that is the certified copy of judgment entitled Eviction Suit 34/2005 has been marked as Exhibit A. And the decree in the aforesaid suit has been marked as Exhibit B. When issued this title, eviction suit was against the plaintiff's brother. Issue number 2, as to whether agreements to sale between the parties dated 5/7/2003 for consideration worth 78,000 was entered into or not. The plaintiff has filed the agreement deed marked Exhibit 1 on record, alleging the same to be signed by the defendants and Hasmukh Thakur, the brother of the plaintiff. The plaintiff and his witnesses have stated in their examination in chief that the husband / father of the defendants, late Darshan Prasad Swarnkar, had taken spare parts from the shop of the plaintiff on credit to the tune of 53,500, and since the said dues could not be satisfied, and as such the deed of agreement of sale of 120 square feet of land together with the shop premises without roof was prepared. So far as the dues amount of 53,500 is concerned, the defendant in the WS and defendant number 5 in his examination in chief have admitted that they had signed the deed of agreement, but in good faith. It has been stated by defendant witness number 1 that due amount of 53,500 was cleared by paying the same to the plaintiff's brother, but instead of returning back the agreement deed, the plaintiff and his brother chose to retain the same on one pretext or the other. They did not return the agreement deed, and it is only after filing of the title eviction suit of 34 by 2005 against Janak Thakur, this agreement paper was produced in the form of this instant suit. The recital of Exhibit 1 nowhere reveals that the fact that the same had been executed after the set-off of 53,500 due from the defendants. According to the deed of agreement, the defendants had to execute an absolute sale deed within 2 months of the date of agreement. There is nothing on record, in spite of oral evidence, that the plaintiff ever
What do you say this comment?
Yes.
This after the court judgment is sustained?
You legitimacy why?
Now let's
There
see
are-
the question of one time.
Yes.
One. Whether yes, please.
an issue of the trial court.
Oh, no, substantial. I've seen, I've read that. It's a short time. Now, the question of law is contradictory interpretation of Exhibit 1. Now, let us see where is the contradiction. Interpretation of Exhibit 1 by trial court in juxtaposition to interpretation of Exhibit 1 by the applicants. Let us see. Which paragraph of trial court judgment should I see for that?
Para 6, but at page 4, the second paragraph.
Let's see.
On the basis of material on record, it is clear that the plaintiff could not produce any.
This is not
No,
readiness
madam.
and readiness.
Yes, never mind. Para 6 only, madam.
According to the deed of agreement, what?
According to the deed of agreement, the defendants had to execute an absolute sale deed within 2 months of the date of agreement. There is nothing on record in spite of oral evidence that the plaintiff ever served upon a notice to the defendants expressing his willingness and readiness. It further transpires that the deed goes on to state that if purchaser fails to pay the balance money to the vendor at the time of registration of sale deed, or fails to get the sale deed registered within the stipulated period, then the vendor shall not remain bound to execute and register the sale deed in favor of the purchaser. In the absence of any document showing the refusal of defendants to execute the sale deed within stipulated period of 2 months, this agreement stands infructuous. My lord, just this. Also, this deed of agreement does not bear the signature of all the heirs of late Dashrath Prasad Swankar, and as such cannot be said to be a valid agreement.
This is the major portion, wherein it says that it is not a valid agreement because all the
All the
years
heirs
of
have not signed the agreement.
have not signed. This is the bone of contention, correct? What about the appellate?
And it is
The agreement does not disclose that defendant number 5, defendant number 5 was representing defendant number 4 as well.
yes.
It is not disclosed. Nor it discloses that he is entitled to execute any deed on behalf of defendant.
Page 3 of the appellate court judgment, my leadership. Paragraph down, sub-para 5 of this para 6.
Subparagraph. Yes, it is there.
I
No,
think
let us see the interpretation made by that.
okay.
That is point of issue number 1, determination number 1. And you will find it here, para number 11. Read it.
जहाँ तक विचारणीय बिंदु संख्या नंबर 1 का प्रश्न है, इस बिंदु पर मैं यह पाता हूँ कि एक और अपील कर्तागण का वाद यह है कि उन्होंने सभी प्रतिवादियों से दिनांक 5/7/2003 को इकरारनामा कराया, जिसके द्वारा प्रतिवादीगण उन्हें प्रश्नगत संपत्ति को बेचने के लिए तैयार थे और जिसका मूल्य 78,000 रुपया तक था, जिसमें 53,500 रुपया प्रतिवादी ने दे दिया, परंतु बाद में प्रतिवादीगण इकरारनामा करने से मुकर गए। जबकि दूसरी ओर प्रतिवादीगण का यह कहना है कि कथित इकरारनामा दिनांक 5/7/2003 का पक्षकारों के बीच हुआ था, परंतु उसका उद्देश्य संपत्ति से बचने को बेचने नहीं था, बल्कि वादी के भैया के द्वारा यह कहना है कि प्रतिवादी के मृत पिता दशरथ स्वनकर के वादी के भाई जनक ठाकुर के से 53,500 रुपए का ऑटो पार्ट्स कर्ज में प्राप्त किया था। उसी कर्ज को चुकता वे नहीं कर पाए, तो उसके सिक्योरिटी के रूप में उन्होंने उक्त इकरारनामा का निष्पादन किया। पक्षकारों के द्वारा साक्ष्य के अवलोकन में मैं यह पाता हूँ कि वादी के अपने साक्ष्य में, जो साक्ष्य संख्या 5 है, ने अपने साक्ष्य में कंडिका 41, 42, 43, 44 etc. एवं 52 में इकरारनामा बनने की प्रक्रिया एवं उक्त 53,500 रुपया के भुगतान के संबंध में अपना प्रत्युत्तर दिया है, जिसमें इसने स्पष्ट रूप से कहा है कि 4 किश्त में पहली बार 10,000 रुपीज, दूसरी बार 10,000 और तीसरी बार 18,500 और अंतिम बार 15,000 रुपीज प्रतिवादीगण को देने की बात कही थी। साथ में यह भी कहा था कि एग्रीमेंट हमारे सामने नहीं बना था। एग्रीमेंट का कागज हमें दोपहर के बाद धनबाद कोर्ट में, जहां श्याम बाबू अधिवक्ता बैठते हैं, उन्हीं के सिरिस्ता के कृष्ण प्रसाद वर्मा लेकर आए और श्याम बाबू से पढ़वा लेंगे। इकरारनामा पर दस्तखत प्रतिवादी के घर पर हुआ। कंडिका 59 में यह वर्णित है। दूसरी ओर प्रतिवादियों का यह कहना है कि इस तरह का कोर्ट कोई भुगतान उन्होंने नहीं पाया। इस बिंदु पर यह पाता हूँ कि प्रतिवादी ने अपने साक्ष्य में जानक ठाकुर के द्वारा दशरथ प्रसाद स्वयंकर को उधार दिए हुए ऑटो पार्ट्स देने की बात कही गई है। साथ ही उन्होंने यह भी कहा है कि उधार में यह इकरारनामा गुड फेथ में बना था। उन्होंने अपने साक्ष्य के कंडिका 25 में यह कहा है कि जनक ठाकुर वगैरह का ये कहना है कि बाबूजी कुछ पार्ट्स उधार लिए थे, उसी की राशि कंसिडरेशन एडवांस के रूप में एडजस्ट किया गया, ऐसा जनक ठाकुर वगैरह कहते हैं। यहाँ ध्यान में योग्य बात है कि दिनांक 5/7/2003 का इकरारनामा जनक ठाकुर के साथ नहीं हुआ था, बल्कि हसमुख ठाकुर के साथ हुआ था, जो इस वाद में वादी है। प्रतिवादी अपने साक्ष्य
कोर्ट की जजमेंट को कैसे सस्टेन करेंगे मिस्टर रॉय? एविडेंस के बेसिस पे एग्रीमेंट इंप्रूव नहीं हो सकता है ना?
नहीं
होगा। डिफेंडेंट नंबर 4 ने रिटन स्टेटमेंट नहीं फाइल किया है। That is not sufficient because plain पे कहीं नहीं लिखा है that defendant number 4 had authorized defendant number 5. Let us assume for a moment. Good testimony. Plain में है ही नहीं. That is not the case in the plain.
प्लेंट में हम बोल रहे हैं सब डिफेंडेंट्स किया,
हाँ,
and the entire written statement was filed, a joint written statement was filed. defendant number 4 does not file a separate written
No,
statement.
but there an objection was taken that defendant number 4 has not signed.
But in a written statement which was filed jointly by all the defendants and
Jointly all, including defendant number 4.
yes, absolutely,
And
and
he-
he files it, and it is sworn by none other than only defendant number 5. Defendant number 1, defendant number 4 never came to the court. He does not file a
Need
written
not.
statement.
Need
He
not.
does not swear an affidavit.
not.
He does not come to
A
the court to
specific
depose.
objection has been taken in para 11 that the suit is bad due to misjoinder of parties as the alleged agreement does not bear the signature of the agreement.
But your lordship, when there is an agreement where all the parties, all the defendants have signed, except defendant number 4,
Be fair to yourself,
I'll be fair. Therefore,
if not to the court.
no, your lordship, he does not file a written statement.
Need not.
He-
You cannot.
he
you
could
cannot,
have this.
You cannot enforce an agreement against a person who is not a signatory to the agreement, nor anybody else is signing on his behalf, nor anybody else is disclosing that he has been authorized on his behalf to sign the agreement, right? And the plaintiff very well knows that there is one more person, that is defendant number 4. He himself has made the party. It is not something he is taken by surprise. He knows that there is one more brother, and he completely ignores the fact that he is not a signatory to the agreement.
Because it was assured that he would sign, he does not sign, but he does not come to depose.
No,
He
that
could
is
have
not,
said,
that is
therefore-
not the page.
Therefore, he could
That
have
is not the tenor of the page.
plaintiff have said that all the defendants they had agreed, and even an oral agreement was made.
Partly
It
oral,
was-
partly written.
It was reduced into writing. It was reduced into writing.
It was reduced into writing, but it does not say that anybody is authorized on behalf of others. Nor does it say that defendant number 4 has agreed to sign it later. ऐसा कुछ नहीं है. Agreement
Dear
has
Lordship,
been executed.
here interesting point is that entire property was 4 kattas, something which was owned by the father.
Part
And
execution specific performance में नहीं.
होता है. Section 12 says so. There are 2 direct Supreme Court judgment on this issue. There is partially against me also, but there are 2 judgments. Your Lordship may allow
You
you.
have not made out a case for part execution. That is not your case.
This judgment, Your Lordship, is. एक मिनट.
और
This-
वैसा तो कोई क्वेश्चन ऑफ लॉ नहीं होता है, हम उससे जाएंगे ही। आप हमको खाली इतना बता क्वेश्चन ऑफ लॉ में आएंगे बस, उसके अलावा
Question of law, but question of law may it is still enforceable against the parties who had signed and who were made defendants. Against them, at least they could not have run away. Entire agreement, how entire agreement would be declared as null
तो
and
यू
void.
विल गेट द मनी बैक।
Now, once I get the money back, that means that they had accepted money from me.
Money. See, therefore the question number 2. Is there any finding that the money was paid? Is there any finding of it? Because there is readiness and willingness to perform the remaining part. The agreement is different from the payment made pursuant to the agreement. As mentioned in the agreement. In the
Yes.
agreement, there is a payment of 54,000.
Yes, 53,000.
It is an agreement.
Because it is reduced into writing.
That's right.
That is very clear from section
You are
92 of.
entitled to that amount. Apart from that, what else did you?
Apart from that, I have not.
Not really. So
That
what
is the
was
reason. That is the reason the appellate court comes to the conclusion that when I have already paid 70%, then for 20%, 20,000 and odd, I could not have said. It could not have been said that I was not ready and willing, because it was not the case of the defendant that they were ready and willing and I was not yet ready and willing. It was their case that they had returned the money back. Strangely, when they take a plea that firstly they did not own any such amount, no such agreement was there. This was their case. But they admitted execution of the agreement. They have said that they have signed. All of them have signed, except defendant. So once they say that they have signed, which clearly mentions that rupees 53,500 had been taken by them. And they take a plea that they have returned the said amount
But
to
that
the.
finding has not come.
It does not.
So there is a finding that they received that. Concurrent finding on that.
Yes.
So there is a concurrent finding on that so far as the receipt of 53,000 and all is concerned. But so far as readiness and willingness is concerned, the appellate court and trial court with respect to section 16C.
Yes.
What is the finding with respect to
I'll show that. Now, what is readiness and willingness, Your Lordship? Till the date when the agreement was entered into, if I had already paid, then that would not be any readiness. What I have done after the agreement,
Certainly.
that is the only readiness I have to show.
That's true.
Therefore, the appellate court, it comes to a conclusion that since I have already paid 70%, and therefore there was no occasion for me to have said, and this cannot be said to be perverse. Any finding, it has to be the appellate court. First appellate court is entitled to come to a finding, and only if it is found that it is absolutely perverse that this finding can be interfered. Here is a finding where the appellate court, on the basis of entire materials on record and the fact that the specific performance of contract is a discretionary remedy, he, after perusing the entire evidences, he comes to this conclusion that yes, since I have already paid 70%, there was no occasion for me to, this could not have been said that I was not ready and willing to pay the other part. And it was not their case that despite they were ready and willing to perform their part by executing the sale deed for after receiving the balance concession amount, then if I would not have paid, the matter would have been different. Here is a case that they firstly deny that there was any sub money which was due to me, and then they also say that they have also already paid. So that their stand also has to be taken. This is a case where both the parties have. And the balance amount was to be paid before the registering authority. If he does not come for registration of the sale deed, then how?
The sale deed was after it was otherwise ready for registration because you have to purchase a stamp duty.
Yes,
You have to take steps.
absolutely.
They were only to join so far as the registration is
Yes,
concerned. Is there any evidence to that?
Your Lordship, unless and until the defendant says that I am ready to execute on this particular date, how this fact would be relevant when they have not taken a plea. If they would have taken a plea that they were ready, but I was the person who was avoiding to pay the balance custodian amount, the matter would have been different. Here they do not even take this plea. Absolutely they avoid, and my statement is that I was ready and willing to pay, but they have avoided, somehow evaded to receive the balance.
So it is not their case that they were ready and willing.
Yeah.
It was your case that
Absolutely.
you were ready and willing.
Yes.
So what is your evidence so far, your readiness and willingness? Did you give any legal notice to them? Did you take any step? Did you give any evidence that you approached them but they refused? Is there anything, oral or documentary, that yes, you went to them and they refused? Fair enough. Was that your case that you went to them and they refused to execute their deed? What was your case?
I have said that repeatedly I asked them,
Let's
but
see.
they only evaded. This is my written
Orally expressed willingness.
statement made in the claim. This is the statement made in the claim.
3 and 4.
Yes.
3, 4 and 3.
Yes.
And what
That
is
is
the
the.
evidence in connection with this? No
This
legal
I have-
notice, not preceded by any legal notice.
No. There is no legal notice which has been done. I have said this and I have proved it by way of my oral evidence.
So, two things very important. One is availability of the fund. It need not be deposited, but availability of the show that it is.
Absolutely, absolutely.
And then your approach to them. Right?
Now, availability of fund would have been important if it would have been an amount which was very high. Here is a case where 78,000 only
Where the amount is high
and
or low.
70% I have already
It's a very
paid.
subjective thing. Right?
Yes, but I have
For
already.
a particular person,
But
200 crore may not be
Therefore, I
high.
say.
And for another 20 rupees may be high.
Therefore, I say that when the appellate court comes to a finding that I have already paid 70% of the 78,000,
See, the fact that you have paid such an
can
amount.
it be said to be perverse? Only
Yes,
one
of course
person.
it's perverse. The merely because the certain amount, certain percentage of amount has already been paid, that by itself does not demonstrate that you were willing to pay the fee. It
Not
is
percentage.
Not 100%.
Not
Whatever,
percentage.
maybe 90% you have paid.
That then your Lordship may see one judgment. There's one judgment where the Honorable Supreme Court in Sardamani Kandappan, I'll just take it. That exact judgment, I'll file it subsequently. There the Honorable Court has said that how readiness and willingness has to be seen, and because I have not brought the judgment because I'll only cite and then I'll place it subsequently in my written notes. If the majority of the amount had already been paid, then that shows the readiness.
You see, readiness and willingness are two distinct words and have different connotations. Merely because, let us assume, after having paid 10%, it can be assumed for a moment, considering your structure as a litigant, that yes, there was no dearth of fund at your end, and you were ready to pay the amount. But so far as willingness is concerned, that requires something more. That requires an overt act. So these two are two different. They are not one and the same. And this also has been interpreted by the Honorable Supreme Court. What is the meaning of readiness and willingness?
But can your Lordship,
And
can
the
this be
readiness of
to such an
willingness-
extent that I have to go and prove that I have actually tendered when many of the payment are actually
There could be a
when
situation.
would I go to the
There
court?
could be a situation that after having entered into the agreement, you have some other prospects. You are not, with the passage of time, maybe short time, you lose interest on the property. There could be many circumstances by which a person may lose interest on the property.
Not when I have.
Not only,
if I would have lost interest if I was not interested, then I would not have paid 3/4 of the amount.
No.
If I have paid 3/4, that means
supervening circumstances after the agreement. And there could be supervening circumstances that later on, maybe that within the span of time by which you were required to act, you did not act. Maybe you found that the money should be invested somewhere else. Then there are
absolutely,
many
I get your
situations
Lordship's point. Then that means I had sufficient fund. So therefore, I had left 70% with the person, and I was not even bothered to take that amount back. Then means I was financially capable
we
to.
are just thinking how the mind would work in a circumstance. Therefore, there has to be some evidence of both readiness as well as willingness. The appellate court simply records the finding. Just have a look.
I'll show. Now there would be other cases also. Therefore, this is my argument. Now let us assume that I enter
Here is
into.
the judgment. You give me the citation. We'll get it right away. You just can't cite it later on. अभी मंगाते हैं. बताइए citation बताइए. अभी एक जजमेंट किए हैं. Before mine, he was arguing for the appeal, and the judgment is on definition hearings. Uploaded.
ठीक है, हम देख. Then last was your lordship said that with regard to readiness and willingness, now there would be a case because repeatedly this would come up. Now if I enter into an agreement and there is a stipulation that I'll be paying balance consideration amount within a period of 6 months or whatever period that is mentioned, then whether I should be apprehensive enough that immediately after entering into agreement, I start writing him mails and writing him letters that please accept the amount. I'll only offer him by showing that I'm ready to pay you the amount. Please register it, and all this would be oral. It cannot be in writing because the agreement itself has been made when the parties were joining issues on the fact that yes, I am ready to purchase the property and the vendor is ready to sell the property. So from the first day itself, I will not be writing letters. I can only offer in, and all this would only be oral and nothing else. I can only make him a request.
Who deposed on behalf of the plaintiffs?
On behalf of plaintiff, there are 5.
Plaintiff deposed?
Yes, PW5. And on behalf of defendant, only defendant number 5, who had filed the written statement here. Only last submission I have, that with regard to defendant number 4 not joining in the agreement, what would be the impact with regard to substantial question of law number 1? Your Lordship may see this judgment because after Kartar Singh there was a dispute when this matter was referred to a larger bench of 3 judges, then this judgment came down. This is identical situation. It may be partially against me also, but Your Lordship may see. Here was also a case where few of the parties had not joined. In our case, before placing this case, Your Lordship, difference between our case and this case I just pointed. Here is a case where the father admittedly owned 4 katthas of land, which also included suit property, which is only 120 square feet of land. Sure, that is all. That means it is only a portion of it, not the entire property that was agreed to be transferred. It was only a portion. So where, let us assume that out of 7 defendants, only 1 does not join. So if he does not join, what would be the impact? That entire agreement itself would be held to be unenforceable because one of them has not joined. When admittedly even if share of other persons are taken out, it would be more than 120 square feet. So they were entitled to transfer their 120 square feet of land, which was only a very small fraction of 4 kattas of land which belonged to the common ancestor. That means the father. Now here was whatever judgment there are few judgments. In all those judgments, entire property was agreed to be sold. Here is a case where only a portion of the property has been agreed to be sold. Then, here Your Lordship may allow me to read it. ultimately section 12.3 has been interpreted in para 7 onwards. 12.3 says if the vendor is unable to perform whole or any part of his contract, then what would be the impact? That is section 12.3, and that has been interpreted by in section 7 onwards. Section 7.12 has also been quoted by the Honorable Court in para 7. May I read it to you? Para 7. Specific performance of part of the contract, where a party to a contract is unable to perform the whole of his part of it, and the part which must be left unperformed either forms a considerable part of the whole, though admitting compensation in money does not admit compensation in money, he is not entitled to obtain for specific performance, but the court may, at the suit of the other party, direct the party in default to perform specifically so much of his part of the contract as he can perform. So here, this is the important portion. The court may, at the suit of the other party, direct the party in default to perform specifically so much of his part of the contract as he can perform if the other party, in the cases of so and so, pays the or has paid the agreed consideration for the whole of the contract, reduced by the consideration for the part which must be left unperformed, and in case falling under clause B, pays or had paid the consideration for the whole of the contract without any abatement in either cases. So then para 12, this is the interpretation. Section 12.3 of the Act is beneficial provision so far as the purchasers are concerned. In the instant case, in view of the finding of fact arrived at by the High Court, the decree for specific performance of contract in respect of entire suit land would not have been granted, as the appellant herein was not authorized by his sister to enter into an agreement for sale. The relinquishment of claim as contemplated under section 12.3.2 of the Act as regards performance of the remaining part of the contract and all rights to compensation need not specifically be pleaded and can be made at any stage of the litigation. Such a plea can also be raised at appellate stage. Delay by itself, it is right, may not stand in the way of plaintiff claiming the relief unless the defendant establishes prejudice. In this case, so and so other cases have been referred. And then the ultimate conclusion, Your Lordship may kindly see para 16. In view of the legal position and also in view of the statement made across the bar, including application for amendment of claim filed on behalf of the defendant, plaintiff respondent in this court, there cannot be any doubt that this court can uphold the decree passed by the division bench of the High Court, relying on or the basis of statement as also upon allowing the application of amendment of claim. It may be true in application for amendment there is no specific abutment as contained in clause 2 of subsection 3 of section 12 of the Act, but the entire application, in our opinion, has to be read as a whole. The plaintiff respondent have referred to the prayers made in the claim and have sought to substitute the same by prayer as noticed herein above, and thus by necessary implication, the relief for obtaining compensation must be held to have been given up. In any event, this last line I am relying on. In any event, such a statement was made at the bar and we accept this. So, if it was only a small fraction of it which belonged to defendant number 4.
What was the nature of amendment made in the claim?
In this case, it was nature in terms of section 12.
So there is no such relief?
No, here we have not.
So,
But yes, therefore I had put stress on para 16 last line. So this statement was made at the bar itself.
आपको सुप्रीम कोर्ट में एडवांस चलेगा यहाँ पे नहीं चलेगा.
अरे, Your Lordship, out of
See,
7,
we are not in first appeal. We are in second appeal.
my only-
Substantial question of law specifically framed. It does not refer to any kind of partial execution of the agreement with respect to part of the property.
Absolutely.
And even if it is part of the property, then also one of the defendant cannot be forced to join.
But here I am the defendant.
You
It is
cannot ask him to join. You cannot ask one of the defendants to join in execution of the sale deed who is not a party to the agreement and say that and under the stage of partition, this particular property will be earmarked to whatever, and then.
But your lordship, out of altogether 7 persons who have signed, they say that they have signed. It is not a case that they have not signed. They sign and only one defendant does not sign. Then how the other 6 can ride on the back of defendant number 4 saying that now after enjoying the money which was paid by me.
Nobody is riding. We are on absolutely low, absolute on point.
Yes,
Do
absolutely.
you want that this particular agreement should be executed by the remaining defendant,
Absolutely.
excluding defendant number?
Absolutely. That is the second point I was,
Will it confer a proper title?
because it is a joint family property which is a, I said that it was a property which consisted of 4 kathas and odd, and this was only a portion of it. He does not separately come and up and say anything whatsoever. He simply he does not file a separate written statement. He joins along with the other defendants also. He could have said that I was not bound by the agreement of. How can others? How can others who have already signed? They can make a statement that because he has not signed, therefore we must also be freed from the agreement which we had entered. That is the only.
My Lordship, just some points, my Lordship, and just
This
one
is all
judgment I would like to. Just one judgment and just 1 or 2 points I would like to state, my Lordship. Just one. My Lordship, this agreement has an express provision saying that if the vendor fails to execute and register a proper sale deed in favor of purchaser within the stipulated period is 2 months, then the purchasers shall be at liberty to make the vendor bound to execute and register the sale deed with the help of proper court, etc. So, and it says 2 months is the stipulated period, my Lordship. It is admitted that this agreement was entered into on 5/7/2003. This title suit was filed sometime in means I got the notice on 14/12/2005.
When was it filed?
Probably 2 months. In the plaintiff, it is not mentioned. In the plaint, it is not mentioned. My Lordship, the date
Anyway, date of filing of this suit?
It
is
was
over
2005.
2 years. And before that, it is also admitted and also tendered in evidence also that this defendant number 5, who was conducting the suit, he had sent a legal notice and was also pursuing a case of eviction against this plaintiff's brother. Right after that, after more than 2 years of the agreement, now they chose to enforce it through. And before that, no legal notice has ever been given to us. And our case is that this agreement was in the form of a security, but they failed to return it.
The plaintiff is PW.
PW5.
Plaintiff, PW5.
My Lordship, and just one judgment, my Lordship. It is a recent judgment by a 3-judge bench in which the issues are quite similar, my Lordship.
Is there any date mentioned as to when did you approach them?
No.
You were supposed to do the needful within 2 months.
Yes.
There is no date.
No. Date no, has not.
Absolutely no date mentioned. So readiness and willingness should be in terms of the agreement.
Yes. But I have said that in para 6 that यह कि मैं बहुत बार प्रतिवादीगण से अनुरोध किया कि वह
You
इकरारनामा की
filed a
तरह
suit after 2 years. I will not say that the suit was part of it. But still, you were supposed to act as per the agreement, and your readiness and willingness was to be demonstrated as per the agreement. Readiness, willingness has also a component of timeline. It's absolutely vague. In the page also and in your evidence also.
But here, Your Lordship, this argument I am repeating, that here it's not a case where the defendants are agreeing.
Whatever be the case of the defendant, you have to make out your own case.
Yes,
You have to
that is
say
what I have
that
made
on
out.
such and such date, at least some date. Readiness and willingness means what? The Supreme Court says that readiness and willingness has to continue even during the pendency of the suit, right? But when you file a suit saying that you were ready and willing as per the agreement, then where is that underlying dates? When did you approach them?
No date has been.
Nothing has been mentioned.
But I have said that I went to them several times and they only bahana banate hain.
No dates.
But
No dates.
therefore I said it is not possible. Let us
No, it
assume.
is very much possible. You see,
Let us assume.
You can certainly
would
get oral evidence
I enter into an agreement with him for sale of his property. Then on the date when the agreement is entered into, on that date there is no dispute between us.
That's right.
So that
But-
dispute would arise only after.
The sale deed was to be executed within 2 months from the date of the agreement. Right? So what is your step within 2 months from the date of the agreement?
It was to be paid before the restraining authority. That was the condition.
So when did
And they say that no, it is not an agreement, I have already paid you back. There is no such agreement whatsoever. That is their stand. And in civil case, Your Lordship, the stand of although plaintiff has to stand and fall on his own legs, but the defendant's stand also has to be taken care of. Where the defendant takes two plea, first takes a plea that there was no such amount which was received by us. Then they say that no, I had returned back the entire amount, and then they also say that I was one of the defendant was not made party in the agreement itself.
We should just, this judgment may also be considered by the this judgment. This 2024 SEC Online SC 2937, Janardhan Das and others versus Durga Prasad Adela. My leadership, similar issues had also been freed, my leadership, in para 7. Whether the plaintiff proved their continuous readiness and willingness to perform their part of the contract as mandated under Section 16C of the Specific Relief Act, and whether the agreement to sell dated so and so was valid and enforceable against defendants number 6 to 8, considering that defendant number 1 lacked the authority to act on their behalf without a valid and subsisting general power of attorney. This is different, my leadership, but it is quite similar. Section 16C of the Specific Relief Act 1963 mandates that a plaintiff seeking specific performance of a contract must aver and prove that they have performed or have always been ready and willing to perform the essential terms of the contract which are to be performed by them. This requirement is a condition precedent and must be established by the plaintiff throughout the proceedings. The readiness and willingness of the plaintiff are to be determined from their conduct prior to and subsequent to the filing of the suit, as well as from the terms of the agreement and surrounding circumstances. The rationale behind this provision is to ensure that a party seeking equitable relief has acted equitably themselves. Specific performance is a discretionary relief and the plaintiff must come to the court with clean hands, demonstrating sincerity and earnestness in fulfilling their contractual obligations. Any laxity, indifference, or failure to perform their part of the contract can be a ground to deny such relief. The importance of readiness and willingness for enforcement of specific performance has been summarized in this case below. And it is true that this remaining amount, it is not required that the amount should actually be tendered to this defendant or even be deposited in court, but still some kind of means some evidence has to be adduced showing the availability of these funds, and also in terms of the contract the plaintiff would have to plead that the plaintiff had sufficient funds or was in a position to raise funds in time to discharge his obligation under the contract. If the plaintiff does not have sufficient funds with him to discharge his obligations in terms of contract, which requires payment of money, the plaintiff would have to specifically plead how the funds will be available to him. To cite an example, the plaintiff may ever improve by adducing evidence, an arrangement with a financier or disbursement of adequate funds, etc. Regarding this notice also there is one in para 9 it has been stated by nature. The trial court rightly concluded that the plaintiffs failed to demonstrate continuous readiness and willingness to perform their part of the contract. The agreement dated 6/6/1993 explicitly required the plaintiffs to ensure that defendant number 6 to 8 would come to Baripada within 3 months to execute the sale deed. The plaintiffs, however, did not take any concrete steps to secure the consent of the presence of the sisters within the stipulated period. They relied solely on
So
defendant
the
number 8.
act within the stipulated period is also a condition precedent.
The trial court observed that the plaintiffs did not issue any notices or correspondences to this other defendants within the 3-month period. Nor did they make any efforts to communicate with them directly or expedite the execution of a sale deed. This inaction on the part of the plaintiffs indicated a lack of diligence and earnestness in fulfilling their contractual obligations. Furthermore, the plaintiffs continued to this is just the facts. In this also it was undivided property and there were co-sharers who were not part of the agreement, and also in this also it was undivided property, my leadership.
2014. Further, when it comes to the agreement, this second opinion has been filed against the judgment dated 9/9/2015, wherein that is deeply signed on 14/9/2015, that appears by the district and judicial sessions judge on 8 November, in that opinion on 156 of 2012, whereby the appeal has been allowed. The appellate court, the first appellate court, has set aside the judgment dated 25/9/2012, within that is deeply signed on 10/10/2012, that is passed by the receiving judge within that is civil division, that includes 6th Dhanbad, in Satisfaction number 52 of 2005, whereby the trial court has dismissed the suit for specific performance of contract instituted by the committee. The appeal was admitted by order dated 17/3/2025 on following substantial questions. The learned counsel for the appellant has submitted that the core of the dispute is in connection with the agreement of sale dated 5th of July 2003, which was entered between the 7 legal heirs and successors of late Dashrath Prasad Swankar, in whose name the property was standing. And on the one hand, and Hansu Thakkar on the other hand. She submits that admittedly the daughters of Dashrath Prasad Swankar and also one son, namely
Rajesh Kumar Verma.
Rajesh Kumar Verma, were not party to the same agreement.
He was a party, but he did not sign. His name is mentioned, but he did not sign.
Name is mentioned.
Yes, in the agreement it has been mentioned, but he did not sign.
Didn't see that. Was not party to the same agreement in as much as the agreement did not contain his signature. The council has also submitted that the agreement did not reflect that one or the other co-sharer of the property was authorized to act on behalf of Rajesh Kumar Verma. She has submitted that in the recital of the agreement, the name of Rajesh Kumar Verma has been mentioned amongst one of the 7 legal heirs and successors of late Dashrath Prasad Swankar, but he was not a signatory to the agreement. He submits that though he was not a signatory to the agreement, he was made party defendant number 4 in the suit. and a written statement was filed on behalf of all the defendants, stating that defendant number 4 was not a signatory to the agreement. The learned counsel has further submitted that as per the agreement, the total consideration amount with respect to the property was 78,000, and out of which 53,500 was said to have been paid, and remaining amount was rupees 24,500. And the agreement revealed that the vendors would execute and register a proper sale deed in favor of the purchaser within 2 months from the date of the agreement at the cost and expenses of the purchaser on receipt of balance consideration amount of rupees 24,500 only due to the registering authority at the time of registration of the sale. It was also stipulated that if the vendor fails to execute and register a proper sale deed within the stipulated time, the purchaser shall be at liberty to make the vendors bound to execute and register the sale deed in favor of the purchaser with the help of court. The learned counsel has submitted that the agreement was executed on 5th of July 2003 and 2 months expired on 5th of September 2003. But the case was instituted seeking specific performance of contract on 6/4/2005. And in the intervening circumstances and also in the plea, there is no specific arrangement as to what steps the plaintiff had taken to show his readiness and willingness to execute the sale. The learned counsel has relied upon the judgment passed by the Supreme Court reported in 2024 SCC Online SC 2937, Janardhan Das and others versus Durga Prasad Agarwal, and has referred to paragraph 7 of the same judgment and has submitted that the state judgment has considered the concept of continuous readiness and willingness as per the mandate of section 16 within bracket C of the Specific Relief Act 1963, and also the peculiar fact as is involved in the present case, wherein one of the defendants of the case lacked the authority to act on behalf of other defendants without a valid and subsisting general power of attorney, meaning thereby all the defendants of the case were not party to the agreement of sale. She has referred to paragraph 8 and 9, 8, 9 and 13 of the same judgment. The learned counsel has submitted that The learned trial court had interpreted the agreement by holding that it was not binding on the defendant number 4 as he was not signatory to the same agreement, and consequently the agreement was not at all enforceable and there was no valid agreement between the parties to same white agreement dated 5/7/2003. She submits that this finding has been reversed by the learned appellate court by observing that the that no separate written statement was filed by defendant number 4 and no evidence was adduced by defendant number 4 and the only person who adduced evidence was defendant number 5. Who deposed that the defendant number 4 did not sign the agreement as he had gone out of station and he had agreed that he would sign the agreement once he comes back. And that the agreement was executed considering the interest of the family. The learned counsel has submitted that though the defendant number 4 had not filed a separate written statement and had not deposed before the court, but a specific stand was taken in the written statement filed by all the defendants that defendant number 4 was not a signatory to the agreement. The learned counsel has submitted that the appellate court was not justified in reversing the decree and the substantial question of law is fit to be answered in favor of the appellant and against the respondents. With respect to the second substantial question of law, she has submitted that the readiness and willingness in terms of section 16 within bracket C of specific relief act is to be seen in the light of the aforesaid judgment in the case of Janardhan Das and others, and has submitted that there is no material on record that the plaintiff had acted in terms of the agreement, and only a vague statement was made in the written statement that the plaintiff has been approaching the defendants for the purposes of execution of the agreement. Although, as per the agreement, the needful was to be done by the plaintiff, the needful was to be done within a period of 2 months from the date of the agreement. The learned counsel has submitted that it is a requirement in law that a party has to act in terms of the agreement to show their readiness and willingness. She has also submitted that though the amount is not required to be deposited before suppose, but the availability of the fund is required to be demonstrated to show readiness and willingness. She submits that the appellate court has recorded a finding in connection with readiness and willingness in paragraph 14 of the agreement judgment by merely observing that the total cost of the property was, value of the property as per the agreement was rupees 78,000, out of which 53,500, that is to the extent of 70% amount was already paid, and therefore it cannot be said that the plaintiff was not ready to buy the property, or was not ready and willing to act as per the agreement. The learned counsel has submitted that the finding of the learned first appellate court on the point of readiness and willingness is contrary to the judgment passed by the Supreme Court in the case of Janardhan Das, and therefore the second substantial question of law is also put to the answer in favor of the appellant and against the respondents. That's all. The learned counsel pleading on behalf of the respondents on the other hand has opposed the case and has submitted that non-signing of the agreement of sale by Rajesh Kumar Verma has been fully explained by the defendant number 5 in his evidence, and accordingly the learned first appellate court has rightly taken note of the evidence of defendant number 5 in the light of the fact that defendant number 4 did not file a separate written statement and defendant number 4 had not even deposed before the learned court. The learned counsel has submitted that the agreement was binding on defendant number 4 in the light of the discussions made by the learned first appellate court, and such finding of fact being based on material on record cannot be said to be perverse in the eyes of the court. The learned counsel on the point of the learned counsel has submitted that the has submitted without prejudice to the aforesaid arguments and has relied upon the judgment passed by the Supreme Court in October bracket 2005 bracket close 5 SCC 142 and has referred to paragraph 16 of the same judgment to submit that merely because in para 16, para 6, 7, 8 and 16 of the same judgment to submit that merely because one of the co-owner of the property, namely defendant number 4, having not signed the agreement, the same is not fatal to the suit seeking specific performance of contract, and the remaining defendants were to be directed to execute the same deed. Direction is for the applicant.
ये डिफेंडेंट्स उसमें नो स्पेसिफिक एवरी डिफेंडेंट
The remaining defendants were to be directed to execute the same deed, and the property being a joint family property at the stage of partition, the property could be adequately distributed amongst the co-sharers.
and the entire property is 4 kathas
The
and
entire
this is only a
property
small
is
fraction.
4 kathas and it is only a small portion of the property consisting of
120 square feet.
120 square feet, which is a shop.
Sure.
The Learned Council has referred to the appellate court judgment and decided that the appellate court has not excluded defendant number 4 from executing the agreement. But the appellate court has considered the evidence on record and has found that the agreement was also binding on defendant. With respect to readiness and willingness to perform the part of the contract, the Learned Council has referred to the plaint and has submitted that specific averment was made in paragraph 5, in paragraph 3 onwards, 3, 4, 5 and 6. With regard to readiness and willingness to perform the agreement, part of the agreement by the plaintiff, the said paragraphs are quoted as under. The Learned Council has submitted that no legal notice as such was given by the plaintiff with regard to specific performance of contract, but the plaintiff had deposed before the court with respect to readiness and willingness to perform his part of the contract. He has further submitted that the case of plaintiff as well as defendant is to be taken together, and it was a specific case of the defendants that there was no agreement and the amount mentioned to have been paid in the agreement was returned to the plaintiff. He has submitted that it was never the case of the defendants that they were ready and willing to perform their part. The Learned Council has submitted that given the plaint and the written statement and the facts and circumstances of the case, the Learned Appellate Court has rightly come to a conclusion that the plaintiff was ready and willing to perform his part of the contract. He has submitted that once a substantial amount of rupees 70 to the extent of 70% with respect to the suit property was already paid, the Learned Appellate Court has rightly drawn a conclusion that there could be no reason for no willingness and readiness to pay the remaining balance amount.
And the said finding cannot be said
And
to
the
be
said
false.
finding which has been recorded by the Learned First Appellate Court cannot be said to be false. He submits that the finding of readiness and willingness has been recorded on the basis of materials on record, and such finding does not call for enactment. However, during the course of argument and the placement of the plaint and the evidence on record, the averments regarding readiness and willingness does not reflect any date on which the plaintiff had taken steps to show his readiness and willingness to execute the sale deed, or the plaintiff had approached the defendants for the purposes of execution of the sale deed, and admittedly the suit was filed on 6/4/2005. The date of agreement is 5/7/2003, and the sale deed was required to be executed within a period of 2 months from the date of the agreement. That is all.
That is all. This is not my submission, Your Honor. This
This
last
is my
portion.
observation.
Yes.
I am observing it.
Yes,
See,
yes.
I am observing
It may not come as my submission.
You see,
Last portion.
this will come as
Yes,
part
yes.
of my
Yes, yes,
These
absolutely.
observations are made for my memory.
Yes, yes.
It will come as a part of my. I just if there is any error in my observation, you would have immediately pointed out that here is
No,
the
no,
material. There is no such material. We have seen, we have scrutinized the evidence. There is no such material as to what you did specifically within a period of 2 months. We'll see what is to be done, whether any perversity is there or not. But it is for my memory because when
Yes.
I write the judgment, I take care of these observations. बार बार हमको वेरीफाई करने की जरूरत नहीं है.
ठीक है.
इसको लेके. The arguments of the parties have concluded. Close this case for further dictation on Monday. I will just dictate.
Yes, yes.
वो reserve
And
करने से
my learned friend says that Hasmukh, he is Hasmukh, Hamsukh नहीं, Hasmukh.
प्लेंटिफ का नाम देखें. मंडे को हम फर्दर
ठीक है, ठीक है.
कोर्ट में लिखा. ज़्यादा लिखाने का है.
नहीं, ठीक है. And we get the indication where it is going.
Yes, yes. Of course, I make it very clear. My mind is absolutely open. Anybody can read it.
Like that.
You can always read my mind.
Yes.
And I don't have any reservation about it. You should know, as a counsel, अगर आपको पता लग जाए कि कोर्ट क्या सोच रहा है, तो आपको easy हो जाता है अपने litigant की बातों को सही से रखना.
हाँ, ठीक है. But I'll not argue anything else.
That's right. प्लेट 3 4 5 6 7 दो लाइन.
Under heading for orders, we
Mr.
decide.
Sharma, where is the other side? उनके absence में नहीं बोलना चाहिए. आपके रिकॉर्ड में आपने और उन्होंने written statement of defendant number 1 to 6 के बारे में बहुत बहस की. When the plate was returned and it was refiled before another court subsequently, plate was returned on account of court fees, मतलब valuation को लेकर दूसरे court में पैसे. Plate was returned, it was presented in another court. Notice issue हुआ to all the defendants. Defendant number 1 to 8, they appeared, prayed for time to file written statement. लेकिन ना ही तो written statement उन्होंने फाइल की, ना ही उन्होंने बोला कि जो written statement previous suit में फाइल हुआ है that should be accepted. ऐसा कुछ भी नहीं, order sheet में भी नहीं. जबकि respondent number defendant number 9 ने appear होकर बोला कि जो हमने फाइल किया है उसी को ले लिया जाए. तो court accepted. The court also recorded that there are trial court का judgment में there are 3 sets of written statements which have been filed, and those 3 sets from the record is the written statement of defendant number 9, the written statement of defendant number 10 to 16, and the written statement of defendant number 17 and 5 to 5D. There is no written statement on behalf of the remaining defendants. आपने इसको पढ़ी नोटिस किया?
नजर पड़ी थी दोबारा देखी
आपको एपलेट कोर्ट का ऑर्डर शीट आपको दिखा देते हैं.
है देखा एप्लेट शीट में है.
इसी वजह से रिटन स्टेटमेंट ऑफ डिपेंडेंट कंट्रोल डिपेंडेंट नंबर 1 to 8 जो है वो रिकॉर्ड पे है ही नहीं. इट इज नॉट देयर इन द रिकॉर्ड. और हम तो इसी को
लेकिन इन्होंने इसका सारा रिकॉर्डिंग किया है इनके जजमेंट में ट्रायल कोर्ट के जजमेंट.
हाँ
ये बात
उसमें लिखा है कि 3 सेट ऑफ रिटन स्टेटमेंट फाइल.
और इनका रिटर्न स्टेटमेंट का सारा स्टेटमेंट्स भी आया है।
आने से थोड़ी हो जाएगा,
आया।
अब तो फर्स्ट एपेलेट कोर्ट में है ना।
लेकिन ये पिकुनरी पॉइंट वाला जरा देख लेते हैं।
अब क्या देखना, आपको हम जजमेंट ही करेंगे, लेकिन आपसे कंफर्म करना चाह रहे थे, वो भी अदर साइड नहीं है, आप लोगों ने रिकॉर्ड नहीं देखा।
इस पॉइंट पे चलिए। हालांकि उस दिन
वो एपेलेट कोर्ट का जो
पॉइंटेड
एक सेकंड, वो जो रिकॉर्ड है गोयल जी के पास है, वो बोलिए जो एपेलेट कोर्ट का जो ऑर्डर शीट
एपेलेट कोर्ट नहीं, ट्रायल कोर्ट।
नहीं, ट्रायल कोर्ट का जो रिकॉर्ड है 2012 वाले सूट का, वो जरा एक बार रिकॉर्ड दीजिए।
इसमें हजूर हम उस दिन बोले थे रिटर्न स्टेटमेंट इज आई कुड नॉट फाइंड द रिटर्न
It is not there,
नॉट
and rightly not there. It was never filed by them.
बट ही हैज नॉट अप्रोच्ड एंड ही सेड यस
Yes, no.
so
sir,
I was also under impression that he is the best person to
वही
say.
ना, रिकॉर्ड नहीं चेक करके बहस करिएगा तो यही होगा, you will be under the impression of
I-
गलती होगा,
I-
हम लोगों से कौन इसको झेलेगा, आप बताइए।
I had pointed out कि इसमें रिटर्न स्टेटमेंट नहीं, rather my lord has said that for this there is no reason to delay the
नहीं है ही नहीं तो ऑर्डर शीट में 2012 वाले जो सूट रीफाइल हुआ था उसमें तो होना चाहिए ना रिटन स्टेटमेंट, कम से कम इतना तो बोलेगा ना कि भाई प्रीवियस सूट पे हम जो फाइल किए थे उसी को एक्सेप्ट कर दिया जाए, उसका रिकॉर्ड मंगाकर, लेकिन वैसा भी कुछ नहीं। दे हैव बीन रिपीटेडली आस्किंग फॉर टाइम टू फाइल रिटन स्टेटमेंट एंड अल्टीमेटली दे डिड।
कंटेस्टिंग वाला तो उसमें शायद है देखता
इन लोगों का
स्टेट वाला जो कंटेस्ट मेन कंटेस्टिंग
की बात कर रहे हैं,
तो है
बुलाइए जरा,
बुलाया रिकॉर्ड
अगर रुकिए हम आपको ऑर्डर शीट आप कितना भी कोई बहस करें बिना रिकॉर्ड देखे हमको केस नॉट करेंगे, आई विल टेक माय ओन टाइम बिकॉज़ आई हैव टू ओन इट। फर्स्ट अपील में तो हमको सब चीज देखना है, कोई चीज हम छोड़ नहीं सकते। आप जरा वो अभी आ नहीं गए।
Under heading for orders with defect, item 1, first appeal, filing number 8669 of 2024.
This is defective.
Yes.
Your Lordships can have a look at the last order list 27 to 25.
Yes.
Let's we have filed 3 interlocutory applications. The defects were, first defect was the remaining defect 15-day limitation in the main application. We have filed 1 IA for that. 1 IA we have filed the defect, and that also relates to defect only. The plaintiff number 2, 5 and 8 they have died, and their legal has substituted notes, that is another IA. And 1 IA is the delay in the substitution petition notes. So if these 3 IAs are allowed, the defects will go.
It is a substitution.
Substitution of legal heirs of plaintiff number 2, 5 and 8 years.
Yeah, local plan is there.
Yes,
Seek instructions for WhatsApp. I have here WhatsApp. Next time
आपको तो टाइम ऑलरेडी मिल
notes.
क्यों नहीं पाई?
अभी तक इंस्ट्रक्शंस नहीं आया तो भेज
नहीं आया तो अच्छी बात है ना, दे आर नॉट प्रपोजिंग, वी आर नॉट ग्रांटिंग टाइम। फर्स्ट अपील में आपको कितना डिले?
15 days.
15 days.
कितना भी हाथ पाँव मार देंगे, 15 दिन का डिले तो तुमको हो ही जाएगा। डेट ऑफ डेथ
Yes. Date of death is in the substitution residence.
बोलेंगे वो जो एपेलेट कोर्ट का जो ऑर्डर शीट है जिसमें रिटन स्टेटमेंट वगैरह फाइल करने के बारे में वो जो लेकर देख रहे हैं लाए जस्ट निकाल के दीजिए मुझसे। ये तो evidence है ना, इसका order sheet है। ये 2022 एक और होगा, एक और होगा 31 अक्टूबर। Mr. Sharma, What is the date of death, madam?
Yes, that is in the IMS 1336. Exit number 2 died on 28/12/21.
28,
12/21.
12/21. Delay is how much?
It's that notes delay in substitution means that delay means is that delay is not be pointed out by the office notes. We have just filed on our own. So the office has pointed out the delay of 15 days. That is means that you lordships can first take that. That is IE number 2511. 15 days delay.
5, 1 month of 25, 15 days delay in substitution.
That is pointed out to the office notes.
In substitution.
No, that is 15 days delay in filing of the main appeal. That is the defect pointed out by the office notes. The IE 2511 of 25 is for that.
So that is a separate thing. What
Yes.
about substitution?
Substitution is the office has not pointed out notes. We have filed together with the IA we have filed in limitation notes.
And legal year substituted legal years have been made party. That is your IE number is?
That is IA number 2118. We have filed this IM notes for removal of defect number 25-2, which says that plaintiff number 2, 5 and 8 are not part of memo of appeal.
Okay.
Since they had died, so they are legal heir substitution. So far that defect decided.
They died after the.
During the pendency of the suit itself, notes, the court has written DDD there, but notes they were not substituted.
This is not taking any steps for substitution during the pendency of the suit.
Yes, please.
They may have to respond. Others will respond while we have last chance. It is not a case that after the decree somebody has died.
In fact, the court notes if the judgment is seen, the court has written in the side DDD. So it should have been done there only. It is not been done. 46, page 46 minutes. 258.
First appeal number, first appeal with bracket filing, bracket close number 8669 of 2024. The learned counsel for the parties are present, the learned counsel for the respondents paid for and is granted time by way of time of 3 weeks by way of last indulgence to respond to all the intermediate applications. सारा पार्टी असेंबली का भी करेंगे, ठीक है? Post on 16th of April. Mr. विशाल कुमार तिवारी was arguing on this. उनके पास सिमिलर नंबर, ठीक है, उसमें डेट पड़ा हुआ, कुछ जजमेंट्स हो सकते हैं, से ठीक है। उसमें उनके केस में कुछ डेट पड़ गया है, इसलिए तो ऑर्डर हो ही गया।
Item 2, first appeal, filing number 11044 of 2024.
What we says to be
FA number 110 filing number से 11044 of 2024 comes before the applicant, raised for and is allowed time till 2nd of April to remove the surviving defect premium. If the defects are removed within time, court is based on date. That case is still आज ही है?
हाँ.
अच्छा हम ध्यान देंगे। हाँ पर orders में
Yes, Dr. Order will depend.
serial number कौन सा?
Number 11. Daily list.
ये 11 वाला फाइल है।
एक
इसमें जो ऑर्डर होगा ना मैडम, मतलब अगले डेट में आप उसको यूज कर लेंगे। आज इसमें ऑर्डर करेंगे। सीरियल 11 में
2
अपने
3 4
serial number
महीने
7. Serial number 7.
7
Not sure.
FA 136.
इसका जरा फाइल अलग करेंगे तो
signature.
सिस्टम देखे नहीं है
2, 3, 4 में same right.
2 3 4 में सेम होता है
Under heading for admission, item 6, content civil 1071 of 2023.
Order not complied.
Yes, why have you not complied with the order?
Your Ladyship, we have filed a show cause dated 12th March, Your Ladyship. The order has been complied on behalf of the state, Your Ladyship. However, this petitioner was an employee of RIMS, so the dispersal of the areas of salary will be done by RIMS. We have regularized his services and they haven't made RIMS a
approval
part.
by the minister has been done.
Yes.
Where is it that?
Para 7, Your Ladyship, of the show cause. That it is stated that the Joint Secretary Health, Medical Education and Family Welfare Department, Government of Jharkhand, by its memo number 1311 dated 11/2/2025 has regularized the period of the petitioner, that is 17/4/2021 to 31st/1/2005, as waiting for posting in light of Finance Department resolution.
Where is the council for RIMS?
Your Ladyship, they haven't made RIMS a party in the contempt petition. However, RIMS was party in the writ petition, as respondent number
We'll
4.
drop it. आपको RIMS से payment आ जाएगा ये लिखा है
Your Ladyship, let us implicate the part them.
ऐसा कहानी नहीं चलता
Your Ladyship, the
Content
payment.
civil 1071 of 2020 ऐसा से मतलब है ना आ जाएगा
They don't pay.
RIMS has to be, Your Ladyship. We have done.
The learned counsel for the parties are present. This petition has been filed. Alleging non-compliance of order dated 7/12/2022 passed in WPS number 7182 of 2012. The learned counsel appearing on behalf of opposite party has submitted that the show cause has been filed by affidavit dated
12th March 2000.
12th March 2025 on behalf of opposite party number 2, wherein a statement has been made in paragraph 7 that the Joint Secretary Health, Medical Education and Family Welfare Department, Government of Jharkhand, by memo dated 11/2/25 has regularized the period of the petitioner from
Your Ladyship, it will be 17/4/2001.
17/4/2001 to 31/1/2005. The learned counsel has submitted that the period has been wrongly mentioned as 17/4/2021 to 31/1/2005 instead of 17/4/2001 to 31/1/2005. She seeks permission and is allowed to make necessary correction in paragraph 7.
And para 8, we have specifically mentioned that RIMS will be paying the areas of the salary.
The learned counsel has also submitted that in para 8, it has been stated that the opposite party number 2 has complied with his part of the order, and so far as payment or disbursal of areas of salary is concerned, the same shall be paid by Larding Institute of Medical Sciences, Kalyapur branch. He has submitted that RIMS or their authority are not party in the present proceedings, but otherwise also there is no impediment on the part of RIMS to disburse the amount in favor of the petitioner once the period has been regularized. after hearing the learned counsel for the parties and considering the fact that needful has already been done by opposite party number 2, this court is not inclined to proceed any further in this matter proceedings. However, it is observed that the petitioner may approach RIMS for the purposes of dispersal of the amount arising out of regularization of the period of his service given from 17/4/2001 to 31/1/2005 and produce a copy of the that should be sufficient.
Right.
From the daily list, under heading for final disposal, item 4, first appeal 171 of 2024.
In this case, Lord, I have paid only 2 time will granted. Yesterday we have given the license being law.
And she's it's like an advance of this circulation.
To be any date may be fixed loss.
Immediate party पिछली बार क्यों नहीं?
पिछली बार very unfortunate to say, Lord, on that day nobody appeared before the courts, Lord. So therefore we have also not appeared, Lord.
लेकिन अब तैयार हैं?
Yes, yes, Lord.
आज तैयार नहीं?
उस दिन तैयार है.
ऐसे ही होता है समय में जाने के बाद क्या ही
सब पर्सनल.
responding combination
प्रशांत पल्लव.
please start with you. मोबाइल फोन है कि
How would you will name appear in the list, Lord? नाम भी appear कर रहा है list में.
every number 171 उनको क्या खबर कर दी होगी कि हम पे एडवांस
नहीं, हम खबर नहीं किया. Sorry for that. We have not informed.
whether the case is right for hearing में नो कैसे लगता है ऐसा क्या हो गया है जो इसमें इट इज नॉट राइट फॉर हियरिंग इट इज अदरवाइज राइट ना
इस
रिकॉर्ड आ गया है
रिकॉर्ड आ गया. इस हो गया. इस
The learned counsel for the appellant seeks the judgment and submits that an advance notice seeking adjournment has been filed before this court. He submits that the matter be posted after 2 weeks and undertakes that he shall not seek any adjournment in the next day. Circulation भी नहीं चलेगा. ठीक है? Will the appeals on behalf of the respondent. Respondents. Considering the aforesaid facts and the undertaking given by the learned counsel for the appellant, goes this case on second appeal under the same heading. that a copy of this order be forwarded to Mr. Prashant Pandit, who is advocate on record for correspondence. सर आपने देख लिया? नहीं। अब आप मिस्टर शर्मा कहाँ हैं? उनके साथ बैठे थे। उनके साथ नहीं ऐसे नहीं सर उनके साथ बैठे। रिकॉर्ड आपके पास है ऑर्डर शीट पे। नहीं है ना? हाँ आप देख आराम से। और ये चीज जो है आपके लिए ट्रायल कोर्ट में लिखा है कि 3 सेट रिटन स्टेटमेंट फाइल
आपके रिटन
हाँ 3 सेट में किसका है वो आप देख लीजिए।
Under heading for orders with effect, item 6, first appeal 164 of 2018.
So court has been calculated. I have to deposit. So 2 weeks time may be given to deposit the court fee. First thing is that, and second is I have to explain the further delay. For that purpose, I have filed a supplementary to the IA. There is a delay of 1687 days. There is a delay of total 1687 days. For previously, I filed a limitation petition. That time only delay was 4 months. But after calculating from the date of filing of the certified copy of the appeal order, now it's coming to 1687 days, for which I have filed a supplementary affidavit to the IA of limitation.
क्या बोलना है? कोर्ट फीस आपने अभी भी नहीं फाइल की।
अभी तो कैलकुलेट हुआ 2-3 दिन पहले।
कोर्ट फीस फाइल करेंगे तब ना
जी।
लेकिन नंबर 164 और 2018. The learned counsel for the appellant has submitted that has prayed for and is granted time till 4th of April to remove the surviving defects. If the defects are removed within time, close this case on 8th of April.
Okay.
In the meantime, it will be open to the respondents to file a response to the interlocutory application seeking confirmation of delay, along with the supplementary affidavit to the interlocutor.
Item 7, first appeal 136 of 2024.
First to
लास्ट
11 उस वक्त हम चले गए थे एडजर्नमेंट मेरे साइड से
પછી પાસઓવર અને બેંકો પાસઓવર
second applicant.
Under heading for hearing under order 41 rule 11 of CPC item 8, second appeal 306 of 2019.
Leadership, the second appeal has been filed arising from judgment dated 15/6/2019 and civil appeal number 03 of 2009. Leadership, I have prepared a brief foundational facts for your current perusal.
You are the plaintiff or the defendant?
Leadership, I am the appellant.
You are the appellant, plaintiff or the defendant?
Leadership, I am the appellant in the first appeal and thereby in the second appeal.
What was your status in the matter?
In the title suit litigation, I was the plaintiff. Suit was dismissed litigation. However, I would like to bring to discuss the matter.
Appeal was dismissed.
Appeal was dismissed.
So concurring finding.
Concurrent finding.
Plaintiff is the appellant.
Plaintiff is the appellant. Would you say? Leadership 1, Safad Sheikh was the recorded tenant of plot numbers 551 and plot number 270, which is the suit property leadership. Now, Safad Sheikh had 4 children. The eldest of them was Abdul Rahman Sheikh. Now, Abdul Rahman Sheikh, these 4 children had partitioned the property amicably, and Abdul Rahman Sheikh had gained 19 katthas out of these 2 plots. Abdul Rahman Sheikh thereafter had, by way of hiba, gifted the entire inherited property to his son-in-law, who is the original plaintiff in the title suit. Leadership, the contention here is that the validity of hiba has not been examined by the trial court as well as the first appellate court. For that, leadership, I would like to point out paragraph 18 at page 50 of the memo of appeal.
The right of Abdul Rahman must have been examined.
The right of Abdul Rahman was examined, and the right of
If he did not have the title, the matter ends.
Abdul Rahman inherited the property from Shafat Sheikh. So he had the title flows from inheritance, and thereafter he gifted the property.
Is there any finding on partition? Partition had happened.
Leadership. Leadership, page number 45 of the memo of appeal.
Let us see the title, the issues framed by the title.
Leadership, page 29.
There is a issue, is hiba valid, genuine and binding?
Yes. Leadership, I'm pressing on that issue.
This has not been
This has not been satisfactorily examined by both the courts.
satisfactorily is one thing. Not answered is another.
Leadership, it has not vaguely answered. It has been vaguely answered.
Where is the finding? You are only concerned with issue number 7.
Leadership.
Where is the finding of the learned trial?
Leadership, paragraph 37 at page 32. On the other hand, it has been pleaded on behalf of the contesting defendant that Abdul Rahman Sheikh never transferred plot number 551 or 270, the suit property, to the plaintiff. Rather, plaintiff manipulated those plots in the deed of hiba belevas without knowledge of the executant in connivance with the deed writer. Hence, the document was later on cancelled by the executant by deed number 4088 dated 25/9.
This you are reading in page number?
Leadership, page number 32 of memo of appeal, paragraph 37.
32. Paragraph 36.
This is the finding with regards to validity of hiba.
On the other hand, this is not the finding. This is the case of.
Leadership.
We will find it paragraph 47.
Paragraph 47, leadership. On going through the materials and evidence available on record, I find that the plaintiff has filed this case for declaration of right, title and interest over the suit land on the basis of hiba belevas deed number 429 dated 5/12/1986 executed in his favor by Abdul Rahman Sheikh. Further declaration that the plot number 70 was written by mistake in place of plot number 270. But the exhibit 1, the said deed of hiba belevas, and statements of the witness to go to show that the plot number 270 has already mentioned in the original deed. There is manipulation and fabrication in the original deed, and the said deed has been tampered. No relief can be granted on the basis of tampered document. There is no explanation that how the number 2, the 470, has been inserted in the said deed of hiba belevas. such and such is tampered and fabricated documents does not convey any right title address in favor of the plaintiff, hence these issues decided against the plaintiff. Ladyship, I want to take you to the first appeal.
Para number 46. There is a concurrent finding that this particular document is forged and fabricated.
The ladyship, the first appellate court have not delved into the aspect of fraud. However, they have delved into another issue. There was another contention that the said HIBA was cancelled subsequently. For that, ladyship, I would like to take you to page number 50 and 50, page number 50 of the appeal, paragraph 18. I would like to read that. Page number 50, paragraph 18. True it is that no oral or documentary evidence to show that Heba Bil Ewas Exhibit 1 executed in favor of the plaintiff, subsequent deed was cancelled in his lifetime by Abdul Rahman, has been filed or brought on record on behalf of the defendants. But here is a case where the PW2 Abdul Sheikh, who was the plaintiff on oath, has admitted the existence of title suit number 43 of 2003 filed by Vedina Baby, defendant. There is admission that plaintiff PW2 and his son PW1 close number that the suit of court number has been filed for cancellation of deed in question, still pending in the court of subordinate judge Bangkok. Ladyship, paragraph 19.
Continue reading, don't read half sentence.
Furthermore, PW2 Abdul Sheikh has disputed the suit properly, saying that the area as 1.5 katta as Hiba Bil Ewas was gifted by him in favor of defendant number 1, Vedina Baby. Legal principle and mean particularly in civil natures, cases as envisaged under section 58 of Indian Evidence Act is well settled that the facts admitted need not be proved. Moreover, it is also settled principle of law that the plaintiff can succeed on the strength of his own case and it cannot advantage the defendant's weakness. Therefore, non-proving of details about cancellation of Exhibit 1, it has not been proved, ladyship. By subsequent deed, the part of defendant does not matter. However, ladyship, we need to examine whether the validity of Heba Bil Ewas is legally binding on all the defendants, which is not there is no finding in both the courts, in both the judgments, about the legal sanctity and validity of the Heba.
Read paragraph 15.
Paragraph
Paragraph 15.
In this context, after perusal of oral evidence of PW6, who is formal in nature and has been examined to prove the deed in question as Exhibit 1, it would appear that he did not know Hindi language. Deed in question has been written down in Hindi script. He even was unable to prove the signature of the writer who put his signature in Hindi. Be that as it may, after going through Exhibit 1, it appears that manipulation in inserting 2 before 70. In the context, looking to the oral evidence of PW1, I find that he, being the son of the plaintiff, has been examined to say that defendant number 1, who in relation is one of the daughter of Abdul Rahman and Sali of plaintiff, after having taken Abdul Rahman in her confidence, afterwards created several illegal, false and inoperative documents. The defendants of the title suit leadership have created such documents. After the death of the plaintiff, appellant, this PW1, as one of his heirs, has been substituted as appellant number 1 in the instant appeal. He admitted on oath that the plot numbers 270 and 551 are found mentioned in Exhibit 1 against the claim by the defendant that defendant number 1, Vedina Baby, who admittedly being the Sari of the plaintiff, is his Morsi in relation. Ladyship, I would like to bring to your notice the fact about plot number 270. The delimitation and the markings of the plot is similar to, which is given in the Heba Bil Ewas, is similar to the plot of 270 and not plot 70. So it was a genuine mistake on the part of the executant that 2 was not mentioned in the deed.
So that has a whether 2 is mentioned or not mentioned. But this document cannot be acted upon, no? If there is a mistake.
But ladyship,
mistake intentionally or unintentionally?
Ladyship, the plaintiff, the original plaintiffs were in peaceful possession of the said plot 270. since the
You
time
could be in peaceful possession of property by virtue of whatever rights, but not by virtue of this hiba. Isn't it? And you have stated that 2 was wrongly inserted, by mistake inserted, but the claim is in connection with plot number 270. The claim is not in connection with plot number 70.
leadership plot number 70 is something completely different, not in the
Very
picture.
different. We do not know identity of property when it is specifically mentioned in the deed.
Leadership, it was a registered hiba, valid hiba executed in favor of the plaintiff.
So therefore, we will read only 270. 270 is mentioned,
Leadership.
and it has come that 2 has been inserted by mistake. Means what? Right? Second appeal number 306 of 2019. For the council appealing on behalf of Takina, this second appeal has been filed against the judgment dated 15/6/2019, decree signed on 1/7/2019, passed by the District Judge 1 Part 2 in civil appeal number 3 of 2009, whereby the appeal has been dismissed and the judgment dated 30/6/2009 within rapid decree dated 13/7/2009 that was passed by learned Subject 1 Part 2 in District number 6 of 2003 has been informed whereby the suit was dismissed. The learned counsel for the appellant, by arguing the matter, has submitted that although there are contrary findings of both the courts, but both the courts have not properly examined the hiba bin hibas, which was a registered deed number 429
Of 1987.
of 1987. And therefore, the judgment being perverse, substantial question of law being framed, and the secretary be admitted for final law. After hearing the learned counsel for no other point has been argued by the learned counsel for the appellant except with regard to the findings regarding legality and validity of the law. After hearing the learned counsel for the appellant, this court finds that a suit was filed seeking declaration of right character interest of the plaintiff, and a further relief that it be declared that the area boundary description and classification in the deed number 429/87 resembles with that of plot number 270 and not of plot number 70, and insertion of plot number 70 in the deed was a mistake. A further relief was also sought, seeking possession of the plaintiff over the personal property be confirmed. A prayer for injunction, both temporary and permanent, was also prayed for. The learned trial court framed the following issues for consideration. case of respective party, इसमें include judgments. Issues at para number 31. Considering the argument of when it comes to the document, the issue number 7 and 8 are important. These issues were taken together by the relevant High Court in paragraph 55 as issue number 6, 7 and 8.
Leadership, on the point of the validity of IVA, I would like to submit a judgment. Just on the point of validity of IVA. Leadership, the relevant paragraph is paragraph 13. I would like to read that out. The conditions to make a valid and complete gift under the Mohammedan law are as under. The donor should be seen and measured and must be the owner of the property which he is gifting, which was there. The thing gifted should be in existence at the time of hiba. If the thing gifted is divisible, it should be separated and made distinct. The thing gifted should be such property to benefit from which is lawful under Sharia. The thing gifted should not be accompanied by things not gifted, that is, should not be free from things which have not been gifted. Point number F, edition. The thing gifted should come in possession of the donee himself or of his representative, guardian, or executory. Leadership, the possession is not disputed in both the proceedings.
Paragraph 15, to submit that the condition for a valid gift, valid and complete gift has been enumerated in the state paragraph, and in the present case, all those conditions are satisfied. Now please do this. Have a seat. The High Court considered all the materials on record, both oral and documentary. And observe that the basic theory of alternative was that there is deed of Hiba bin Hiba's number 429 of 87 was that in the state deed lot number 270 was already mentioned by inserting figure 2 before 70, but this by same manipulation it's an Indian by considering the oral and documentary basis, the learned Frankfurt ultimately held that the plaintiff had filed a case seeking declaration of right capital and interest of the resident property on the basis of Hiba bin Hiba's deed, and deed number 429 dated 5/12/1986, executed mistake in the base of 270. The learned court recorded that the exhibit 1, the HIBA and the statement of the witnesses goes to show that plot number 270 was already mentioned in the, as already mentioned in the original deed. There is manipulation and fabrication in the original deed, and the same deed has been tempered. And no relief will be granted on the basis of a tempered document. The learned tribunal also recorded that there was no explanation as to how the number 2 before 70 has been inserted in the deed. The HIBA with HIBA's number 439 dated 5/12/1986 has been held to be a tempered and fabricated document, and it was held that it did not convey any right title interest in favor of the plaintiff, and the issues were decided against the plaintiff. Evidence on record, and recorded its findings in paragraph 15. And recorded that as per the oral evidence of the 2, the son of plaintiff also said his evidence goes to show that 2 due to mistake by its deed writer was omitted before 17, and this mistake was bona fide. The learned appellate court also referred to one title suit number 43 of 2003, which was said to have been filed by defendant number 1, seeking cancellation of the deed in question, which was still pending before the subordinate Judge Pakud. Therein, he had affirmed that plot number 270 has been shown in the exhibit 1. The learned court ultimately recorded that the oral evidence of PW2, the plaintiff himself, in his cross-examination, referred to total area 1.5 kattha with respect to land to plot number 270, claimed to have been gifted by way of Hiba bill was in favor of the number 1. And the appellate court recorded that on collective reading of paragraph 15 and 21 of the W2, it basically concluded that the suit property was not the same as was mentioned in the schedule appended with the plate. And his narration totally brushed aside his right title and interest over 3 kattha 9 group under plot number 270. Para 17. The learned court also thus the learned court, the learned appellate court ultimately dismiss dismiss the appeal, considering the finding of facts reported by both the courts in connection with discrepancy/manipulation in HIBA, this court is of the considered view that no substantial question of law is involved in this case, and no perversity in the matter of appreciation of evidence has been pointed out by the learned counsel for the appellant, calling for failure of any substantial question of law. So far as the judgment passed relied upon by the learned appellant, when it comes to the appellant is concerned, the basic ingredients to make a valid and complete it under Mohammedan law is not in dispute, but in the present case, the entire case was based on HIBA, which was found to be manipulated, and discrepancy was found, and therefore the trial court has rightly refused to decree the suit in favor of the plaintiff. The second plea will be dismissed. आप लोगों ने देख लिया? नहीं है ना?
नहीं, इसमें पुराने प्रोसीडिंग में 1 to 8 का फाइल हुआ
था, लेकिन इसमें तो नहीं ना टेकअप किया।
लेकिन
प्लेन
10
जब दोबारा फाइल हुआ,
वो भी लेकिन रिकॉर्ड पे नहीं,
वो भी नहीं है,
जो पुराना
ये है नहीं।
और
लेकिन इस सूट में तो नहीं आया रिकॉर्ड पे।
इस सूट में ये चीज आया है कि 3 सेट अपॉइंट किया।
हाँ, 3 सेट हो गया ना। 3 सेट, एक डिपेंडेंट नंबर 9 का है, एक डिपेंडेंट नंबर 10 to 16 का है, एक डिपेंडेंट नंबर 17, 5, 8 भी।
हाँ, तो ये 5 to 8 जो है
5 to 8 नहीं है,
5 to 5D 5 to 5D का रिटर्न स्टेटमेंट में लिखा हुआ है कि वी आर अडॉप्टिंग रिटर्न डिपेंडेंट फाइल बाय 1 to 8, ये चीज लिखा है।
लेकिन जब 1 to 8 ने फाइल ही नहीं किया तो क्या अडॉप्ट कर रहे हैं?
उसमें फाइल किया,
इसमें फाइल तो नहीं किया ना।
इसमें
1 to 8 ने अगर इसमें फाइल किया रहता तब तो वो अडॉप्ट करते, लेकिन जब 1 to 8 ने इसमें फाइल ही नहीं किया तो क्या अडॉप्ट करेंगे? और सबने यही लिखा है कि 1 to 8 ने जो फाइल किया है उसको हम अडॉप्ट करते हैं, जबकि 1 to 8 ने इसमें फाइल ही नहीं किया।
1 to 8 उस केस में फाइल किए थे।
हम लोग कैसे उसको लेंगे बताइए? हाउ डू वी टेक इट ऑन रिकॉर्ड? जबकि डिपेंडेंट नंबर 9 ने आके बोला है कि जो हमने उसमें फाइल किया था वही हम एक्सपेक्ट करते हैं, वो देयर इज अ स्पेसिफिक ऑर्डर एक्सेप्टिंग।
हां, ऑर्डर तो इन लोगों के बारे में।
जब प्लेट दोबारा फाइल होता है, सिर्फ प्लेट फाइल होता है ना, रिटन स्टेटमेंट थोड़ी अपने ऑटोमेटिक सारे रिकॉर्ड नहीं ट्रांसफर हुआ है इसमें। द प्लेट वाज रिटर्न फॉर फाइलिंग बिफोर
The plate is same. It has been renumbered.
Maybe it is same.
It is same. It is renumbered.
Renumbered. The plate is same, but dependent का written statement नहीं है रिकॉर्ड। आप कोई भी लॉ लगा दीजिए, आप मतलब पुराना सूट में written statement को आप इसमें रीड नहीं कर पाएंगे, और इसीलिए आप ट्रायल कोर्ट में लिखा है 3 set of written statements have been found. Clear लिखा है 3 set।
लेकिन केस तो उन्होंने इनवैलिड दिया टोटल। लेकिन जो अलग वाला जो
एविडेंस आया है, हम कंसीडर किए हैं, वो सब चीज अपनी जगह, लेकिन जो
डॉटर्स वेयर लेटर ऑन मेड पार्टी, उनके रिटर्न स्टेटमेंट में जो आया, जो न्यूली एडेड रिटर्न स्टेटमेंट जो
उसमें आया है कि डिपेंडेंट नंबर 1 to 8 ने जो फाइल किया उसको अडॉप्ट करते हैं, फाइल नहीं किया। और
उनका भी बहुत सारे गवर्नमेंट्स हैं जो कि
वो ठीक है, दैट इज ओके, लेकिन इनका रिटन स्टेटमेंट नहीं है।
इनका रिटर्न स्टेटमेंट रिकॉर्ड में नहीं है, सो फार एज दिस
ऑर्डर शीट में भी नहीं है।
उस और पहले वाला जो हमने देखा 2011 में, उसमें भी नहीं।
उसमें तो
नहीं, देयर इज एन ऑर्डर टू डेट ऑर्डर हमने देखा
नहीं, उसमें है
12/3/2012।
अरे भाई हम कहां बोल रहे हैं कि उसमें नहीं फाइल हुआ, लेकिन इसमें तो रिकॉर्ड पे नहीं।
रिकॉर्ड में लेकिन नहीं, उस रिकॉर्ड में
उसको हम क्यों पढ़ें? हमें क्या जरूरत है पुराने सूट का कहानी पढ़ने? पुराने सूट का कहानी सिर्फ डिफेंडेंट नंबर 9 के लिए पढ़ेंगे, क्योंकि उन्होंने बोला है कि हमारा अडॉप्ट किया है।
10 to 16
बात करते हैं, वो है हमारे पास।
10 to 16 का भी आया
10 to 16 तो उसमें थे ही नहीं।
नहीं इसमें आया
इसमें आया?
हाँ, इनका
10
इनका
to
रिटर्न
16 आया है, 17, 5, 8 to 5 भी आया है। 9 का आया
इन सम एंड सब्सटेंस इनका रिटर्न स्टेटमेंट वही
आ गया है, लेकिन हमको तो लिखना पड़ेगा
हाँ नहीं
ना।
ठीक that is a that objection is proper
वापस
उनका रिकॉर्ड नहीं है उसमें।
चलिए वापस।
इनको एक लाइन कम से कम लिखना चाहिए था कि सो
हम एक्सेप्ट करते हैं।
हम हमारा जो पुराना वाला है उसको हमको अडॉप्ट कर लेना
नहीं,
वो नहीं उन्होंने नहीं लिखा
वो रिकॉर्ड वापस करें।
हाँ देखिए
Item 9, second appeal
जब
146
नहीं
of
है तो हम तो नहीं कहेंगे तो खुद कह ही रहे हैं
Yes, appellant.
मिलोड सीनियर सर राजीव शर्मा कोर्ट में 4 में है, बोले नेक्स्ट डे रख लूँगा।
क्या चीज?
सीनियर सर राजीव शर्मा
हाँ।
बोले अभी कोर्ट में 4 में है, तो बोले कि सर नेक्स्ट डे रिक्वेस्ट कर देने के लिए रख दीजिए।
1000 रुपये फाइन देके आपका पहली बार बात है ना? 2 बार 1000 रुपये फाइन देके एडजर्न बिना फाइन के हम एडजर्न नहीं करते। कितना फाइन करते हैं वो भी बता दें। ऐसे नंबर 146 of 2022. 11 Council for the appellant seeks adjournment. No advance notice seeking adjournment has been circulated. Earlier the case was adjourned on 26/9/24 upon payment of cost of ₹1,000. Thereafter it was adjourned on 29/1/2025 again. Thereafter it was again adjourned on 29/1/2025, but this time without payment of cost, as the senior counsel had submitted that he was not paid. And while adjourning the matter, it was observed that no further adjournment will be granted. Today, a prayer for adjournment has been made. However, considering the prayer, the matter is adjourned and is directed to be posted on कौन सा तारीख को बोले हैं?
नेक्स्ट डे
हाँ?
नेक्स्ट डे
Next day मतलब
कल
कल
जी
कल के लिए
या नेक्स्ट वीक कर देते सर।
हम नहीं जानते ऐसा नहीं। 8th of April, subject to payment of cost of ₹10,000. Adequate prior to the next date of hearing, pending which this appeal shall stand dismissed without prejudice to the issue.
Item 10, second appeal 11 of 2023.
Last occasion it was, office was directed whether any other appeal has been filed, because there were 3 appeals in the court below.
I don't find.
Milord, I was not getting what with that office was asked to inquiry.
Just wait for them. ऐसा कुछ ऑफिस को डायरेक्शन होती है और ये हम लोग का काम नहीं कोई बात नहीं इसी को कैसे बाकी लोगों ने नहीं फाइल किया बाकी केस में नहीं फाइल हुआ बट दे मस्ट हैव एक्सेप्टेड द जजमेंट आप बताइए ये वाला केस
I pray one thing, only one, एक दिन के लिए कुछ, because I am trying my best. Huh? I am trying my best to. Yesterday I had come from outside, some family work, functions. Lord, the appellant before your lordship is the original plaintiff. Appellant. Suit for partition was filed. There are 3 sets of defendant first party, second party, third party, and thereafter one intervener defendants they had come. And the intervener defendant had challenged the genealogical table of the plaintiff, and relying upon two scheduled land which was in the name of Gangia Panditai. They are saying that they are not related, although the documents were on record with regard to the parcha showing that the father of Gangia they are all legal heirs of Sukho Pandit. The finding of the appellate court is at page 111.
शेड्यूल 1 का तो पार्टीशन कर दिया,
हाँ, शेड्यूल 1, 2 का
सिर्फ शेड्यूल 4 का नहीं,
नहीं किया।
ओनली शेड्यूल 4। प्रॉपर डिस्क्रिप्शन नहीं है आपका शेड्यूल 4 का।
It is described, but he is saying that since it was recorded in the name
No,
of
no. Further, the plaintiff and other defendants have not properly described the land mentioned in Schedule 4. By amendment in the plain, the land of Schedule 4 of the plain was added, and it was pleaded by the plaintiff that the land of Schedule 4 of the plain stands recorded within joint possession of Aklu Pandit,
Yes.
Pandit, Bandhu Pandit.
Aplu Pandit, Budhun Pandit, Bandhu Pandit. In addition, written statement dated so and so filed by Jhaji Panditain, defendant first party, who was pleaded that the plaintiff and these defendant have joint land also in village Bande and Mansoria, where some of the suit properties situated recorded in the name of Aklu, Bhuvan, Bandhu, which are also not partitioned among Aklu and heirs of Bhuvan and Bandhu Pandit. Remaining defendants, including intervener defendant, have stated nothing about the land described in Schedule 4 of the plan. During examination, the witnesses have stated nothing about the said land. The parties have not filed any documents relating to the land of Schedule 4 in evidence. In such facts and circumstances, I am of the view that it would not be just and proper to declare the share of the documents was with regard to the parcha showing that they are related to each other, Milord. And
रिलेशन की बात ही नहीं है ना, शेड्यूल 4 प्रॉपर्टी के बारे में क्या डॉक्यूमेंट है?
parcha is there.
पर्चा मतलब
The Khatiyan is there.
एग्जिबिट नंबर
That I am saying. Yes. Lord, that is exhibit 5 to 5.3 of Basori. 5 say 5.3 of Basoria village.
पेज नंबर
JB number just
आपका देखिए शेड्यूल 4 पेज नंबर 57 में डिग्री, ठीक है?
Yes.
इसका दिखाइए कौन सा 5 to 5 trimesters को लेना देना। ये है ना
That Khatian is, that is exhibit U4 on behalf of defendant number 5 to 9. They have produced U9 with regard to जवाबंदी number 1 खतियान पर्चा के अकलू पंडित वगैरह के नाम से
एग्जिबिट नंबर बताइए।
U4
पेज नंबर कहाँ से?
page running page it is 34, internal page 17 of the trial court judgment where it is described with regard to खतियान ब्रदर्स यू को ग्राम बसवरिया जमाबंदी नंबर 1 के खतियानी पर्चा है जो अकलू पंडित वगैरह के नाम से है। Yes, lower portion. We have shown our relation with Aklu Pandit in the general table, which was denied.
आपका ट्रायल कोर्ट में है, उसको डिसमिस कर दो।
Yes.
पूरा नहीं।
नहीं, with regard to that.
वो डिसमिसल कहाँ है? वो पैराग्राफ है।
that is with regard while deciding issue, is in page. एक शॉर्ट एडजस्टमेंट खाली एक डेट का खाली एक दिन का खाली